Hello, greetings from Colorado Springs. My name is Lance Kohler, and I'm the broker-owner of the Cornerstone Real Estate Team. We're doing a 4-part series covering the new laws that went into effect over the last 12 months in Colorado that pertain to property management. Today, I'd like to talk to you about the Rental Application Fairness Act, House Bill 19-1106, and this went into effect in August 2019. Now, the Rental Application Fairness Act primarily applies to fees that are charged during the rental application process. But there are a couple other provisions that we'll cover here in a moment. So the application fee, the change to this is your application fee must be used for processing the tenant's application. You have to use the entire amount to cover your costs in processing. And I'll cover in a moment, if you don't use the entire cost, you have to refund those to the tenants. Now, there are two ways you can determine your cost basis or your expenses for processing an application. You can use the actual costs as you process that individual's application, or you can use an average expense based off all the applications that you've processed and come up with what your application fee will be. The application fees must be the same. You can't charge different fees, higher fees to a certain property or a certain group of tenants and lower fees to another group, obviously. And you also have to disclose to the tenants how the fee is used. So you have to lay out your expenses, how much it costs to process, how much it costs for the software maybe that you're using for the application, the time involved in processing the application, for example. And then you have to provide a receipt to the tenant for the application fee. Also under this bill, as I stated just a minute earlier, you have to refund any unused amounts. So if for some reason you didn't incur those expenses in processing this individual's application and you still have $30 remaining, you have to refund that back to the tenant. Some of the other provisions that came with this bill. You can only, if you're using rental history and credit history as a criteria in your application process, whether you're going to approve or disapprove a tenant, you can only use the rental history and credit history within the last 7 years. Can't go back further than that. Criminal history, if you're using that as criteria, will be convictions only. So you can only use convictions, you cannot use arrests with the new criteria, and only within the last 5 years. Also in this bill, it requires written notice when applicants are denied, and you must state the reason for denial. And any violations of this on the fee side or the criteria side, you can be held, you as the landlord or landlord's agent could be held for treble damages, triple the amount of the application fee plus court costs plus attorney fees. Now I said earlier you could only use criminal history within the last 5 years, but there are a couple exceptions. Those exceptions are for meth and amphetamine offenses, sex offender related offenses, homicide and stalking related offenses. Just to recap, in this bill, if you're in violation, you would be liable up to 3 times the amount of the application fee plus the tenant's court costs plus reasonable attorney fees. The tenant is required to provide you notice 7 days before they were to take you to court if they felt you were in violation of this. And if the landlord corrects or cures the violation or alleged violation, then they are not liable for the damages. If a tenant would make a meritless claim against you, the landlord, they would be responsible for your court costs and reasonable attorney fees. Hopefully this was helpful to you. Please stay tuned for the remainder of the series. Thanks. Have a great day.